Hi guys, today we are going to discuss the law on sales, and we'll talk about law on sales. We talk about the contract of sales. All right. So in this video, we will be discussing the definition of sales, of the contract of sales, the elements to a contract of sales, and the characteristics of the contract of sales. When the law defines contract of sales as a contract whereby one of the contracting parties obliges himself to transfer the ownership of and to deliver a determinate thing, and the other party obligates himself to pay the price certain or its equivalent. All right. So based on the definition of the contract of sale, there are two parties to the contract of sales. These are the seller or the vendor and the buyer or the vendee. The seller or the vendor obligates himself to transfer the ownership of the thing and to deliver the determinate thing. And the buyer or the vendee obligates himself to pay the price certain in money or its equivalent. Okay, so what are the elements to a contract of sale? Elements to a contract of sale are classified into two: the essential elements to a contract of sale and the natural elements to a contract of sale. When we discuss the law on contracts, guys, there are three kinds of elements to a contract. These are essential elements, natural elements, and accidental elements. Of course, the contract of sale will follow the three kinds of elements: the essential, since it is a contract, the essential elements, the natural elements, and the accidental elements. So when we talk about essential elements, all other kinds of contracts will have the same essential elements. Okay, so same consent, object, and cause. Well, the consent in the contract of sale is manifested through the offer on the part of the seller, and the consent on the part of the buyer is manifested through his acceptance of the offer as to the object and as to the price. When we talk about the object in the contract of sale, it requires that the object must be a determinate thing. When we talk about determinate thing, it simply means a thing that is physically segregated or particularly designated from the rest of its class. And it also needs to have the cost. And the cost in the contract of sale is the price. And the law on contract of sale requires that the price must be certain. Okay. Let's go to the natural elements to a contract of sales. These are warranty against eviction and warranty against hidden defects. Well, when we distinguish the natural elements from the essential elements, the essential absence of any of the essential elements will make the contract void. But absence of any of the natural elements will not make the contract void. Violation to any of the natural elements will just make the contract rescissible. Okay, what are the characteristics to the contract of sale? Contract of sale is consensual. When there is meeting of minds between the buyer and the seller as to the object and as to the price, the contract of sale is then and right there and then perfected. Okay, regardless of whether the object is delivered or not yet delivered, when there is meeting of minds between the buyer and the seller as to the price and as to the object of the sale, then the contract of sale is perfected. It's different from real contract. Real contracts are perfected by delivery, while formal contracts are perfected by execution of certain formalities. So you need to take note, guys, that the contract of sale is consensual, not real contract, not formal contract. The contract of sale is also principal because it exists in itself. It can stand alone. It does not need any other contract for this contract to be entered into. Unlike preparatory contracts like the contract of agency the contract of partnership, wherein this contract are entered into for the agent to enter into another contract. So you need to take note that the contract of sale is not preparatory, it is principal. It can stand alone. It's not also accessory because the contract of sale exists in itself. It can stand alone. And an accessory contract cannot exist in itself. It cannot stand alone. It needs any other contract. Just like, for example, the contract of mortgage. Contract of mortgage is an accessory contract. It needs the contract of loan for the contract of mortgage to exist. So, you need to take note, guys, that the contract of sale is principal. Contract of sale is also bilateral. Okay, it needs two parties. It's not unilateral, wherein it requires only one party. Contract of sale is onerous because it requires the payment of the price and the transfer of ownership. So it requires an exchange of more or less of things of equal values. Unlike gratuitous, wherein it does not require an exchange or it does not require any consideration, just like the contract of donation. Contract of sale is commutative because, as I have said, it requires more or less an exchange of equal values. It's not aleatory, just like the contract of insurance, wherein the values in exchange of is dependent on the happening of the event. Okay, it's nominate because the law gives it a specific name. Law on sales or contract of sales. It's not innominate, wherein innominate contracts has no name given by law. So these are the basic considerations when it comes to the contract of sales, guys. See you on the next succeeding videos for the continuation of the discussion on the contract of sales. Bye, guys.